Judgment in the appeal BCL Old Co Limited against BASF plc.
Lord Nance will give the judgment.
The appeal concerns a claim under Section 47A of the Competition Act 1998, brought in the Competition Appeals Tribunal by the appellants against the 3 respondents for damages for operating a cartel contrary to Article 81 of the European Community Treaty, now Article 101 of the Treaty on the Functioning of the European Union. The question is whether the claim is barred by a 2-year limitation period prescribed by Rule 31 of the Competition Appeal Tribunal Rules 2003. Previous proceedings before the Court of Appeal have established, and it is no longer in issue, that the claim is barred on the correct interpretation of the relevant statutory provisions, and that there was no power to extend the 2-year period. The claim is barred because time ran from the expiry of the period for any appeal against the European Commission's decision that the respondents had infringed Article 81. The fact that one of the respondents, BASF, appealed not against that decision, but against the penalty imposed upon it by the Commission for the infringement was irrelevant. The appellants, BCL, now submit that until the previous Court of Appeal proceedings decided conclusively that this was how the time limit ran, the position was unclear, and that it would in these circumstances be contrary to the European legal principles of effectiveness and certainty to hold that its claim was time barred. The Supreme Court, in a judgment given by myself, disagrees and dismisses the appeal. It accepts that national limitation periods must not operate to render practically impossible or excessively difficult the exercise of European Union legal rights. But it holds that this does not require that the interpretation or true effect of a statutory limitation period should be clear beyond doubt. What is required is that it should be sufficiently clear, precise, and foreseeable to enable individuals to ascertain their rights and obligations and exercise those rights without excessive difficulty. In the Supreme Court's view, the present time limit fulfilled this requirement upon a careful reading of the relevant Act and rules. Further, had this not been so, the only consequence would have been that the United Kingdom would have been in breach of its obligations under European law, giving rise potentially to state liability. But that would not have enabled the appellants to bring the present claim against the respondents out of time. European Union law does not require the setting aside, as between civil parties, of a limitation defence successfully established under domestic law on the grounds that its effect was insufficiently clear, precise, or foreseeable before the decision establishing that it existed. The appeal will therefore be dismissed with costs.